Swayam Prabha. Digital India. Educated India.
Welcome to the session on land laws. Today I am going to talk about the local laws and regulations. In my previous lecture, I had talked about the personal laws governing land rights. In that, I had given an overview of Hindu Succession Act 1956, Muslim personal law. There are other personal laws like Christian law of succession, Parsis law of succession, Jewish law of succession. So, basically this personal laws, it deals with the body of laws that basically govern the succession and inheritance of the related family matters like marriage, divorce. So, it may vary from as based on cultural, religious and customary practices. So, it may differ from the other general civil laws of the country, and in that session I had already discussed about the role of judiciary in interpreting and adjudicating the personal laws related matters regarding the inheritance and the challenges and conflicts which were arise there due to the diverse religious communities and how to overcome from that. So, now in today's session I will give an overview of the tenancy laws in different states, implications and recent amendments. So, today's topic is local laws and regulations. In this, basically in India, the governing law for the control of rent or for the protection of the rights of landlord and for the rights of tenant, it is governed by the Rent Control Act. So, this Rent Control Act here lays down rules for renting of premises and aims at ensuring that both tenants and property owners are not exploited by each other. As land is a state subject, it is given in entry 18 of the state list in the 7th schedule of the constitution. It has, each state has its own Rent Control Act. Many states have also come up with amendments to their acts over the years. The relationship between the landlord and the tenant was primarily a state subject. The Housing and Urban Affairs Ministry, however, prepared the model law in an effort to assist states to overhaul their tenancy legislations to promote rental housing in the country. The Model Tenancy Act 2021 is the most recent model tenancy law which is prescribed by the central government. The Model Tenancy Act 2021 has been established to establish a rent authority that oversees the rental of premises. Its primary objective is to safeguard the interest of the landlord as well as the tenant and to provide the faster alternative dispute mechanisms relating to the dispute and related matters. So, this Model Tenancy Act, it was approved by the Union Cabinet and circulated to all states on June 7, 2021 for adoption by way of either enacting fresh legislation or amending existing rental laws suitably. Only 4 states, Tamil Nadu, Andhra Pradesh, Uttar Pradesh and Assam, have revised their tenancy laws on the lines of the Model Tenancy Law circulated by the Union Government in 2021. According to the government, the model law, it basically seeks to promote the rights of the landlords and tenants and provide a transparent, responsible framework for the effective rental of real estate. The draft National Urban Rental Housing Policy 2015 had also noted that the current affordable housing shortage in Indian cities could be addressed only by promoting rental housing. So, this Model Tenancy Act has its own aim, has its own objective to protect the interest of the landlords and the tenants, and for providing transparency and speedy mechanisms for the resolution of dispute and related matters. Now, I will talk about the tenancy law in Delhi. In Delhi, the land related disputes were governed by the Delhi Rent Control Act 1958. So, this is a law that regulates the rents and evictions in certain parts of Delhi. Its main purpose is to protect tenants from unreasonable rent increases and eviction. So, this Delhi Rent Control Act, it was framed here to keep a check on rent and untimely eviction and to provide affordable housing to the weakest section of the city. So, this Delhi Rent Control Act, which is enacted in 1958, is a law that basically regulates the rents and eviction in certain parts of Delhi. There are key points of this Delhi Rent Control Act which are noticeable here, that is, first one is rent control. Landlords cannot charge more than the standard rent for a property which is determined by the Act. Eviction protection is given to the tenants who pay rent on time and follow the terms of their lease agreement generally cannot be evicted. However, there are some exceptions, such as if the landlord needs the property for personal use, because we have section 14 subsection 1 of the Delhi Rent Control Act, which here basically protect the interest of the tenants from eviction. But there are certain clauses, that is A to L of the proviso, which is attached to the said section, which says that an application may be made to the controller in a prescribed manner, and the controller may make order for the recovery of the possession of the premises in favor of the landlord, if the cases fall in such clauses. Like, for example, if the tenant has sublet or he parted with the possession without the permission of the landlord. If the tenant has not paid the whole debt or whole of the arrears after issuing notice after the expiration of the 2 months notice given by the landlord, which is legally recoverable. And if the tenant has not used the building as per the agreement between him and the landlord, so in that case also the landlord may file an application. And if the landlord needs it for a bona fide purpose, like for his residence, for the residence of his family members, then also he can file an application for the eviction of the tenant. If the premises is not fit for human habitant, then also an application may be made to the controller. So, this is a provision, very important provision, which is given here, which gives protection to the interest in the interest of the tenant from eviction. And there are certain clauses, there are certain exceptions. If the landlord needs the property for personal use, only then he can file an application before the controller. There is one more section, section 14 subsection 6, which is attached here with this one only, which protects the interest of the tenant. Next one is increase in rent. Landlords can increase the rent under certain circumstances, but they must follow specific procedures outlined in the Act. There are many landlord rights as well as tenant rights in Delhi, as provided by the Delhi Rent Control Act 1958 under the Delhi Tenancy Act, and these include these rights of the landlord as well as the tenant. It is here, the tenant must pay the rent by the 15th of every month in case there is nothing written in the rent contract. So, if it is not mentioned in the contract or an agreement, the date by what time the tenancy will be expired. So, in that case the tenant must pay the rent by the 15th of every month. The tenant also has the right to ask for a receipt in writing in exchange for the rent. The landlord, he does not have any grounds for eviction under the Delhi Rent Control Act if the rent is being paid in a timely manner, because this is one of the clause A, which deals with, which is given in the proviso of section 14 subsection 1, that only in that case if the tenant has not paid the debt or the rent which is legally recoverable from the landlord, only in that case the landlord may file an application before the controller. Third one is, if the tenant pays a standard rent amount under the act, then the landlord cannot evict the tenant for paying the negligible amount. A key reason why yields on rent in the central part of Delhi is quite low. The landlord is not allowed to increase the standard rent. However, for renovations, the increase cannot be more than 7.5% of the overall expense incurred. The Delhi Rent Control Act, it establishes the rent controller as the key figure in the dispute settlement mechanism between the landlords and the tenants. So, here if the because this is also one of the clause given in section 14 subsection 1 in the proviso, that if the landlord wants the premises for building or rebuilding it or for doing major repairs in the building, then in that case he may increase the standard rent, but it cannot be more than 7.5%. And this Delhi Rent Control Act, as one of the main objective of this act is to provide speedier mechanism for the resolution of disputes. So, in that case also, if there is any dispute arises between the landlord and tenant, then also this act has the provisions to resolve those disputes. The amendments, certain amendments were made in this Delhi Rent Control Act till that time when it was enacted in 1958 due to the shortcomings in the act. The first amendment in Delhi Rent Act started off in 1988 with Delhi Rent Control Amendment Act, and according to section 3 clause C of the Delhi Rent Control Act 1995, the premises with monthly rent exceeding 3500 rupees would not fall under the previous Rent Act of 1958. So, this was here amended by this Amendment Act, and with the latest amendments in Delhi Rent Control Act, eviction laws were regulated. The tenants acquired rights towards the property, and the latest amendments did not affect the rights the tenants already enjoyed with the Delhi Rent Control Act 1958. With respect to section 14 Delhi Rent Control Act, landlords were barred from taking legal action against a tenant on grounds of illegal possession if the lease had expired and the tenant still occupied the premises. I am talking about here regarding this section 14 subsection 6, which also protects the interest of the tenant, because in this subsection 6 it lays down that if the landlord has acquired any premises by transfer, then no application before the controller under section 14 subsection 1 shall lie. Even in any clauses which are there given in the proviso, even if the landlord wants it for his bona fide purpose, even then also he cannot file an application unless and until the 5 years has elapsed if he has acquired the premises by transfer, because the main object of this one is to protect the tenant from the action of the landlord, who basically use this as a device to enable the purchasers to evict the tenants from the premises. So, whenever such cases goes before the court, then the court has to check this thing whether the landlord has acquired the premises by transfer or by other mode. Like we have one case in this V.N. Sareen Ajit versus Ajit Kumar Pople. In that case, there was a partition in a joint family property. One father, the portion, there are 3 portions, one is in the possession of the father, the 2 is in the possession of the sons. So, after partition what happened, the portions has been changed. The father who is in possession of the bungalow came to the in portion, it is in the it comes after the partition to the son, and that is why the tenant who was there in the premises in the bungalow, who was there by the father, then he want to because this portion was given to the son, so he filed a case. He filed an application before the controller for the eviction of that tenant. So, then the tenant raised his contention before the court that as this premises has been acquired by transfer. So, according to section 14 subsection 6, he has to wait for 5 years. He cannot evict him before that time. So, in this case the main issue was this one, whether the partition here it comes under the definition of transfer or not, because according to the Transfer of Property Act, which I had already discussed in my previous slides, in my previous lectures, that it only deals with the transfer of immovable property between two living persons. So, in the transactions which are amounting to transfer of property are the sale, lease, exchange, mortgage. So, these are the transactions in which the transfer is there, because the conveyance is there, and by conveying property from one person to another, it means creating new interest in favor of other person. So, in that case the person can take the benefit of the given provisions in the Transfer of Property Act as per section 5, but there are certain transactions which does not come under the definition, like partition. Partition is not a transfer of property, because there is no conveyance, there is no creation of interest in favor of that person, because in that the what happened, the sharers will get their own shares and it has just been separated only after the partition. Nothing new has been obtained by the co-sharers. They get only their own shares which just now separated after the partition. So, nothing new is there, no conveyance is there, no interest has been created. So, that is why in this case also the Supreme Court held that as the here the mode of transfer is partition, and partition is not a transfer of property. That is why the tenant, he cannot take the benefit of section 14 subsection 6, because here the landlord, he cannot take the he has acquired the premises not by way of transfer, but by way of partition, which is not come under the definition of transfer. So, with respect to section 14 here, landlords were barred from taking legal action against a tenant on grounds of illegal possession if the lease had expired and the tenant still occupied the premises. Then we have Delhi Rent Control Act 2016. The amendment in that Delhi Rent Control Act 2020 with the Model Tenancy Act 2019, this Delhi Rent Act 1958 was amended to formulate Delhi Rent Control Act 2020. So, this is the latest amendment to the Delhi Rent Control Act. The rights of the tenants and the landlords were revisited and detailed again. So, according to section 22 of this Delhi Rent Act 2020, a tenant will remain a tenant by law under these circumstances, and he will be liable for rent contribution towards the property. Delhi Rent Control Act 2020 also saw a capping on the high limit of security fees demanded by the landlord against the rented properties. So, among the provisions of this updated act is the requirement for the creation and registration of rental agreements. The first copy of the agreement here is provided to the tenant, while a rent control authority retains the second copy. So, the provisions of this updated act here is regarding the requirement for the creation and the registration of the rental agreements. Whenever there is an agreement between the tenant and the landlord, it must be registered, it must be it is mentioned in the agreement specifically for what time, for what is the tenure of that agreement, for 11 months, for 2 years, and then the first copy of the agreement is provided to the tenant, and then a second one retains with the rent control authority. Under the Delhi Rent Control Act of 2020, any lapse in the agreement necessitates monthly renewal. So, tenants can remain on the property as long as they are punctual with rent payments. So, tenant can use the premises, he can always remain there in the property when the tenants are punctual in paying all the rent payments in time according to the agreement between him and the landlord. Additionally, a new amendment permits commercial property owners to request a security deposit of up to 2 months, while residential property owners may request a security deposit of up to 1 month. So, according to this new amendment, it permits commercial property as well, and it requests the owners to security deposit of up to 2 months, while residential one, the person has to pay as a security for 1 month only. Now, I will talk about the stand of Delhi on this Model Tenancy Act 2021, which has been established here to for the purpose of establishing a rent authority, which basically deals with the rental of premises. So, this Model Tenancy Act, which was approved by the Union Cabinet in June 2021, and the states were invited to enact it. So, the Delhi Rent Control Act, this law 1958, which will be repealed here by the government, and the new Rent Act will take effect after that. So, since land is a crucial issue in the national capital, the centre must enact the law in Delhi. The traditional lease agreements between the renters and the landlords would not be affected by the new law, because this new law, its main purpose here is to protect the interest of the landlords and the tenants, and to provide a speedier mechanism for the resolution of disputes. So, the traditional lease agreements which were earlier created or which were earlier executed between the parties, between the renters and the landlords, it would not be affected by this new act. Now, I will talk about the tenancy law in Maharashtra. To regulate rental housing, the Maharashtra government passed the Maharashtra Rent Control Bill 1999. Subsequently, the Maharashtra Rent Control Act 1999, it came into effect on March 31st, 2000 to regulate the rental housing, because I am here to talk about on this topic local laws and regulations. So, each state has their different laws with respect to the land. They have their personal, the state has the power to govern local laws for the enactment or for the regulation of these land related disputes. So, after coming into effect, the act here replaced the Bombay Rents, Hotel and Lodging House Rates Control Act 1947. The Hyderabad Houses Rent Eviction and Lease Control Act 1954, and the Central Provinces there are Regulation of Letting of Accommodation Act 1946. The act does not apply to any premises which belong to the government or local authority, bank or public sector undertaking, or state or centre corporation. As per this act, the landlord is responsible for the maintenance and modification of the residential or commercial property. So, this act, it does not apply to any premises which is related, which belongs to the government or public sector undertaking, any local authority, any bank. It simply governs, it simply here for the protection of the landlord and the tenant, and that is why the Maharashtra government passed this Maharashtra Rent Control Bill 1999. The important provisions of this act, of this tenancy law here, I will give an overview of the important provisions, the key points, the essential features of this act. As per section 11 of this Maharashtra Rent Control Act, the landlord here retains the right to decide the rent and is also entitled to ask for a raise in the rent at the rate of 4% per annum from the date of the commencing of the Maharashtra Rent Control Act. The landlord, he can similarly increase the rent at the rate of 15% per annum for the development, for any modification, alteration, if 70% of the tenants has given their written consent. And the additional 25% per annum rise in rent is for particular structural maintenance and repairs specifically carried out under the Maharashtra Housing and Area Development Authority Act. So, as per this section 11, here the landlords are free to retain the right to decide to fix the rent as per the increase, as per the raise in the rent at the rate of 4% per annum from the date of commencing, then they can increase this rate at 15% per annum for the development, for the modification if they want to do in the premises at the rate of this one. Additionally, 25% per annum also give rise in rent as for the purpose of structural maintenance if they want to do that. So, this is very important provision here in this tenancy law. According to section 16 of the Act, a landlord can take possession of the property if the tenant builds any permanent structure without permission. So, if a tenant or any person who is related to the tenant, any servant, any agent, and if he is found guilty of nuisance or annoyance to the adjoining house, the possession can be recovered by the landlord. A tenant cannot use the property for any illegal purpose. A landlord will retrieve the property. In that case, if he used the building for some illegal purpose, then the landlord has the right to retrieve the property. The tenant verification in Maharashtra has been done. So, according to section 16 here, the landlord can take possession if the tenant has built any permanent structure after taking possession from the landlord on the basis of that tenancy right without permission of the landlord, then the landlord has the right to get back the possession of the property from the tenant on this ground. Supply of essential services, again this is one of the main provision. As per section 29 here, a landlord cannot cut vital services like electricity, water supply, light on staircase, usage of the elevator or sanitary services. If a landlord does these services, a tenant can approach the court under section 29 subsection 4. So, there are the rights which are given to the landlord, but as well as the obligations are also attached with that. If the landlord has the right to evict the tenant on these grounds which were mentioned here, which I had already discussed in the previous slide, that we have section 11, section 16. So, this as per section 29, a landlord cannot cut vital services, because this is the right of the tenant to enjoy that building with all the basic amenities. He cannot cut electricity, he cannot stop the water supply, light on staircase, and if he does so, then this tenant can approach the court. Service of the apartment, it is the responsibility of the landlord to keep the premises in good condition. In case a landlord does not repair the property, a 15 days notice is served by a tenant. Again here it is one of the responsibility of the landlord to maintain the premises in a good condition, in a healthy manner, so that the person can survive easily. And in case if a landlord does not repair the property, then a 15 days notice must be served by the tenant, and if even then also the landlord does not that thing and he does not keep the premises in a good condition, then the tenant has the right to go before the authority to take the action against the landlord. It is the responsibility of the landlord also to inspect the premises rented or given. It basically section 28 here of this Maharashtra Rent Control Act. It entitles the landlord to inspect the premises rented or given on license at a reasonable time and after giving prior notice to the tenant or the licensee. It means by this provision, the landlord is entitled to inspect the rented premises at any time when he wants. If something suspicious is there, if he found that the tenant is occupying the premises for some illegal purpose and some unknown persons were coming regularly, so in that case he may inspect the premises rented at a reasonable time and after giving notice to the tenant. Registration of rent agreement, this is again one of the important provision by this Amendment Act which was inserted here. The landlords and tenants must register the rent agreement. The Act says an agreement should be in writing and it registered as per the Registration Act 1908. To get the rent agreement registered is the responsibility of the landlord. If it is not done, then a penalty is levied on the same. a landlord can face imprisonment of up to 3 months, a fine of rupees 5,000 or both. So, the landlord or tenant must register the rent agreements in and the agreement should be in writing, and it must be registered as per the Indian Registration Act, because this comes under the lease agreement, and the lease and the mortgage, these are the transactions which are compulsorily registrable under section 17 under the Indian Registration Act 1908. Next important provision is usage of property. A residential property cannot be used for a commercial purpose. Even a tenant cannot do so. If he found guilty, imprisonment for up to 6 months or rupees 10,000 fine is there, or both is faced by the defaulter. If it is necessary also to provide rent receipts to tenants every month by the landlord, and if not, then a fine of rupees 100 per day is charged. So, if a residential property has been let out by the landlord to the tenant, then it can be used only for that purpose only. It cannot be used for any commercial purpose, and if the tenant has done so, then the landlord has the right to evict him. Next is the transfer of tenancy. It is legal for a tenant to accept money for giving up tenant rights according to section 56 of the Act. Also, a landlord can get money for the grant or renewal of a lease or for giving consent to transfer the lease. So, it is legally legally recognized here that this right of the tenant to accept money for giving up tenant rights. Employee-employer tenancy. This says that an employer can give a premise on rent to an employee. The tenancy should be done in writing for the premises of any part of it. The tenancy is only for time the employee is in service. An employee will have to vacate the premises within 30 days before the end of his service. So, this is the relation here between the employee and the employer regarding the tenancy, by which the employer can give a premise on rent to the employee, but in that condition it should be the tenancy should be done in writing, and it is in writing for the premises of any part which has been given by the employer to the employee. Then registration of rent agreement is there. Landlords and tenants must register this rent agreement, as previously I had discussed. The Act says an agreement should be in writing, it should be all the formalities prescribed under the Registration Act has been duly completed. Next is non-following of Model Law 2021. Because this Model Law 2021, as I had already discussed with you, that this law here has been enacted for the purpose of establishing the authority that oversee the renting of premises. The Maharashtra state government here has already said it would not implement any provisions of the model law that deal with hike in rentals or eviction of existing tenants. So, Maharashtra state government has expressly here mentioned that it would not implement any provisions of the model law. Next, I will talk about the tenancy law in Assam. The Assam Urban Regions Rent Control Act 1972 was enacted in 1972. Its goal here is to temporarily limit the increase in rent within the boundaries of Assam's urban areas, including cantonment areas. Any property rented out for private or commercial reasons is subject to rules and restrictions. It is a legal need for both the parties to have a written agreement stating the rent arrangement. So, the goal of the Assam Urban Region Rent Control Act here is to temporarily limit the increase in rent within the boundaries or within the cantonment areas, within the Assam's urban areas, and through the formation of a rent authority and a rent court at the district level. The Act offers a swift adjudication system for resolving disputes between the landlords and the tenants. This Act also states that the rights and responsibilities of the landlords and the tenants regarding the care and upkeep of the property comprehensively, removing any kind of ambiguity. Hence, there can be no artificial ceiling on the amount of rent that can be charged. So, through the formation of this rent authority and the rent court at a district level, it is helpful in resolving the dispute between the landlord and the tenants by this act. The Assam Tenancy Act 2021, because here the Model Tenancy Act, which was adopted for the first time in Assam, because the Assam Urban Areas Rent Control Act of 1972 is repealed with this bill. The Assam Tenancy Bill 2021 was introduced by Piyush Hazarika, the Minister of Parliamentary Affairs. On August 13, 2021, the bill was passed and it came to be known as the Assam Tenancy Act 2021. So, here this act will provide a speedy adjudication mechanism for the resolution of related disputes and matters between the landlords and the tenants through the establishment of rent authority, a rent court and a rent appellate at the district level. The act further specifies the duties and obligations of the landlords and the tenants regarding maintenance and upkeep of the premises, eliminating any ambiguity in this regard. Because these matters which deals with the rent authority, because a rent court is there, so a person has to file an application. If any dispute arises, then they have to go before the rent authority, not directly going to the court. In spite of going to the court, they have to file an application before the rent authority, because it is expressly given here in the act. The provision is here that the person has to go before the rent court, before the rent authority, before going to the civil court. There will be no artificial cap in fixing the rent of a premises. The rent of a building will be market driven and will be determined by mutual agreement between the tenants and the landlords. Act not to apply to certain premises, because it has certain limitations, it has its own limitations, territorial boundations. So, the act does not apply to premises, such premises owned or promoted by the central government or state government or a government undertaking or enterprise or a statutory body or cantonment board. So, this premises owned by a company, or if any university or through by any organization, the premises owned, then in that case the company, university or organization given on rent to its employees as a part of service contract. The premises owned by religious or charitable institutions as may be specified by notification by the state government. Section 4 of the Assam Tenancy Act 2021 highlights the importance of a tenancy agreement, stating that it is mandatory for the landlord and tenants to have such a document in place. This agreement serves as a legal framework outlining the terms and conditions of the tenancy. So, this act does not apply to the premises which is owned or promoted by the central government or state government or the government undertaking or a statutory body or cantonment board. On the other hand, the section 5 of this act delves into the period for which such tenancy agreements are allowed. It specifies that the duration of the tenancy can be decided by the parties involved and it should be clearly mentioned in the tenancy agreement. This provision offers flexibility to both the landlords and the tenants, allowing them to agree upon a suitable time frame for the tenancy. So, section 5 here it provides that the tenancy agreement has clearly mentioned in that the time for up to what time the agreement is made, for 1 year, for 6 months, for 2 years. So, it has to be clearly mentioned in the tenancy agreement. Section 11 of the Assam Tenancy Act, it mandates that security deposits agreed upon by both landlord and tenant should not exceed 2 months rent for residential apartments and 6 months rent for non-residential apartments, ensuring fairness in the tenancy process. Next, I will talk about the tenancy law in Karnataka. The Karnataka Rent Control Act 1999. It borderlines the rules, rights and limitations that govern the rental landscape in this state. The act proposes an all-inclusive approach to maintain the tenant-owner harmony. This Act was introduced following the expiration of the 1961 Rental Act. The Karnataka Rent Control Act 1999 has impacted the state's rental market significantly because it has provided a legal framework for rental agreements ensuring the rights and responsibilities of both landlords and tenants are clearly defined. So, by regulating the rent limits, the Act has helped here in preventing excessive rent hikes and ensuring affordable housing for tenants. It has also streamlined the process of eviction, protecting landlords from non-paying tenants and tenants from arbitrary eviction. Further, the establishment of rent court and rent tribunal has provided a platform for quick and fair resolution of disputes, reducing the burden on the judicial system. The rights which are stated here in this Act, in the Karnataka Rent Control Act 1999, it ensures that tenants are treated fairly and have a secure living arrangement. Here are some key rights that tenants have under this Act. The security of tenure is there. They have the right to enjoy security of tenure, which means that they cannot be evicted from the rented property without a valid reason. So, the landlord must provide a notice period of at least 3 months before initiating eviction proceedings. Fair rent, the rent amount is determined by taking an aggregate of the property value at the time of construction and the amount incurred during construction. So, the standard rent calculated, it should not exceed 10% per annum of the aggregate value. This measure here is to prevent landlords from charging outrageous rents to their tenants by providing the fair rent in the protection of the tenants who has been exploited by the landlords in the need of money from charging this outrageous rents to their tenants. Next ground is maintenance and repairs. The landlord is responsible for maintaining the rented property in a habitable condition. In a good condition, they may charge a small fee for maintenance as well from the tenant. However, maintenance charges, it should not exceed 10% of the total rent. Additionally, the charges for amenities provide, it should not exceed 15% of the total rent. It also provide the provision for non-discrimination, because tenants cannot be discriminated against based on their caste, religion, gender or any other grounds. The Act prohibits landlords from denying rental accommodation to tenants on discriminatory grounds, because most of the time what happened, the landlords usually deny to give the premises to the persons who belong to the different caste, if suppose who is not a Hindu, who is not of the Brahmin caste. So, these are the examples. In that case, the landlords, they usually not allow the person to take the premises or to stay there as a tenant. So, non-discrimination is there in this Act. Right to privacy, tenants have the right to privacy and peaceful enjoyment of the rented property. The landlord cannot enter the premises without the tenant's consent, except in cases of emergency or with prior notice. 2 months notice has to be served to the tenant if the landlord want to inspect the premises for a valid reason, not for any illegal. If suppose he found that the person was the tenant had used the building for some illegal purpose, then he has a solid ground, then he can give an application, he give notice to the tenant. Next is legal recourse. If the tenants believe that their rights have been violated, they can file a complaint with the Rent Control Court. The court has the authority to take appropriate action against landlords who fail to comply with the provisions of the Act. So, if the tenant felt that their rights have been violated, then they have the right here to file a complaint before the authority, before the Rent Control Act against such activities of the landlords, and the court has the authority here to take appropriate action against the landlords. Now, I will talk about the duties of tenants as well. When the tenants has the right, they have the obligations also, and as a real estate advisor, it is important to understand the rights and responsibilities of the tenants under the Karnataka Rent Control Act. So, here some of the points are given regarding which the tenants need to adhere: paying rent on time, because tenants are required to pay their rent on time as agreed upon in the rental agreement. Failure to do so may result in legal consequences. Maintaining the property. Tenants are also responsible for maintaining the property in good condition. It is not only the duty of the landlord to keep it in a good condition, to maintain the building whenever it is not in a condition of the human habitant. So, this includes keeping the premises clean, taking care of any repairs and not causing any damage to the property. Next point is using the property for intended purposes. Tenants must use the rented property solely for its intended purposes as specified in the rental agreement and must adhere to the property or the building rules, because this is one of the ground for the eviction if the tenant has used the premises for the purpose for which it was not let out. So, if it was not let out for the commercial purpose, then the tenants had to adhere to that following those conditions and has to follow those terms and conditions which were there in the agreement. So, this is one of the reason, this is one of the duty of the tenant to take care of this thing. Next is giving notice before vacating. According to the Karnataka Rent Control Act, tenants are required to give a written notice to the landlord before vacating the property. Pending repairs or maintenance dues should be cleared before vacating the property, because sometime what happen if an agreement is there for 11 months, but the tenant want to leave it for earlier for some reasons, for some valid reason, then he has to give a written notice to the landlord. Now, I will talk about the eviction rules under the Karnataka Rent Control Act. Under this act, landlords can evict tenants on various grounds such as non-payment of rent, subletting without permission, causing damage to the property, or using it for activities it was not intended for. Notice period for the non-payment of rent is 2 months, subletting without permission for that 30 days is there, and the act specifies the notice period that landlords must give to tenants before initiating eviction proceedings. Similarly, tenants vacating the premises before the end of the agreement term needs to serve the notice period decided in the term. The Karnataka Rent Control Act 1999, it allows for the inheritance of tenancy rights in certain cases such as death. This provision ensures a smooth transfer of tenancy rights to the legal heirs. So, by this one can inherit the property, like if tenant's right is there, and if the before the death of the tenant, if the tenant made a will and give his tenant right to his legal heirs, then they were entitled to inherit the property, because the provision is here. It allows for the inheritance of tenancy rights in certain cases if the death is there, for example. So, this provision, it ensures a smooth transfer of tenancy rights to the legal heirs. Now, the Karnataka stand on model law, whether they implemented the provisions of the Model Tenancy Act or not, this is given here. The Model Tenancy Act 2021, which is introduced by the Indian government, aims to bring about significant changes in the rental housing sector. So, Karnataka, one of the leading states in real estate, has also shown interest in embracing this act. This decision here to adopt was heavily influenced by sudden surges in the property rent prices paired with increasing dispute rates, though the act is yet to take full shape in Karnataka. So, in the last, I would like to conclude that in India, tenancy law is a state subject, which is given in the entry list 18 of the state list, by which the different states have different laws with respect to the land rights. So, meaning that each state has the authority to enact its own legislation governing landlord tenant relationship and tenancy agreements. So, this means the each state has the authority to enact its own legislation, like as I had already discussed about various local laws, like we have the tenancy law in Assam, in Karnataka. So, these laws, these states have their different rules with respect to the rights given in these acts, the provisions given in these acts regarding the protection of the landlord and the tenant. This allows here for flexibility in addressing local needs and concerns related to tenancy, rent control, eviction procedures and dispute resolution mechanism, but state laws of several states falls short. Because here the one thing important which is to be noted, very important, that this Model Tenancy Act 2021, the main aim, the main objective of this act here is to provide a speedy resolution mechanism for the dispute between the tenant and the landlords or the related matters. So, this act here establish a rent authority that oversees the renting of premises. So, without going or without wasting the time of the court, because courts are already overburdened. So, in that case here, if the express provision are there in the local laws, in the act, in the Model Tenancy Act is there. So, it allows flexibility in addressing these concerns which are related to the tenancy, related to the rent control, related to the eviction procedure, that they can mention before the rent authority. It is essential that states should try to align their tenancy laws either by amendments or by new enactments to the model tenancy legislation released by the union government. This will bring greater uniformity in legislation and standards, along with retaining the provisions which are essential here to fulfill the unique demand of a state. So, after this session, I think you will be able to understand how important these local laws are, the regulations regarding the disputes between the landlords and the tenants, the tenancy laws in each state, like I had discussed about the Assam Tenancy Act, Karnataka Tenancy Act, we have Model Tenancy Act 2021, we have Delhi Rent Control Act in Delhi. So, the governing law in India for the control of rent, for the protection of the rights of landlords, for the protection of the tenants, these are governed by their local laws, by the regulations, by the authorities which are there in the act. And section 14 of the Delhi Rent Control Act, it gives it provides protection to the tenant. Likewise, in other states also, in Assam, in Karnataka, in those states also, in those acts, by the amendment, they had made provisions for the disputes, for the speedier mechanisms between the parties. So, by this one can sort out their dispute if they have an agreement between them regarding the lease agreement, regarding the tenancy agreement between the landlord and the tenant. They can file an application, they have to know about their rights, about their obligations, what they have to follow, what they have not to do with respect to the premises, with respect to the their act against the tenant and tenant against the landlord. So, this is vice versa responsibility of both the landlords and the tenants to follow the rules and the regulations which are there in the act. So, as I have mentioned here that this these laws basically deals with the particularly primarily for this purpose to for the renting of the premises. We have the section various provisions, like in Delhi we have Delhi Rent Control Act, as I had already mentioned. So, after this one can very well aware about their rights as a tenant, about their rights as a landlord, how they can evict the tenant when the tenant is not paying the rent. There are various grounds which are given in the local laws as well as in the Delhi Rent Control Act. If the tenant has sublet the building without the permission of the landlord, in that case if the landlord requires it for his own bona fide purpose, then these are the circumstances, these are the grounds on which the landlord can file an application for eviction. These are the grounds for the eviction of the tenant. And for the disputes which arises regarding their rents, regarding the untimely eviction, if one want to file a case, then he has to follow these provisions which are given in the local laws, which are given in the Delhi Rent Control Act, without straight going forward to the before the court. They have these authorities, Rent Act, they have to file an application before the controller. So, these are the provisions which I have discussed in this session. So, hope you will be able to understand now the local laws with respect to the rights of the landlords and the tenants, what are the duties, what are the responsibilities as a landlord and the tenant. Thank you.
Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. Today I want to tell you a little bit about what sociology is. In order to go ahead and study sociology, one of the things you need to develop is a sociological way of thinking. Now, this capacity to think in a sociological manner was termed as the sociological imagination by an American sociologist called C. Wright Mills in 1959. He argued that in order to think in a sociological manner, you should be able to have two different skill sets. The first skill set would require you to have the capacity to think beyond the problems that individuals face. So, if you encounter a problem that some one individual is facing, you should be able to connect it to a broader public problem. Mills gave the example of people in his neighborhood. He says if there is one person who is unemployed in the neighborhood, that seems to be an individual problem. But as a sociologist, you're expected to dig around a little. So you come across a couple of other people in your neighborhood who are also unemployed. That indicates to you that rather than being a specific problem, there is a larger public issue at hand. So as a sociologist, you're supposed to look at individual problems and see how they are connected to broader public issues. The second capacity that you're expected to develop as a sociologist is the capacity to link an individual's biography with history. Historical thought may not come to you as the first thing that's connected to sociology, but it plays a pretty important role in the field. So Mills argues that rather than looking at a problem in the here and now, it's important to trace that long historical trajectory that may be connected to this individual problem. Let me give you an example from India, right? Let's say you look at the women in your family. Let's see at what age do they get married. So you may see that your sibling is getting married at the age of 25. Go back one generation. At what age did your mother get married? You may find that she got married a little younger, let's say 21. Go back another generation. At what age did your grandmother get married? You may find that she got married even younger, 18 or possibly even younger than that. So this capacity to see how the history of a family then influences the age at which your sibling got married, that is the capacity to bridge the biography of a person, or rather by a biography we can also think of the biography of a particular problem with history. What has happened in the past? How is that connected to this individual or this problem in the present? Thank you.